Okay, I think we are ready to begin. Hello, everybody. I'm Keith Cooper. I'm the vice chair of the Beverly Hills Bar Entertainment Law section. And today's speaker is here to talk about from deal to dispute litigation lessons for entertainment transactional attorneys. One note, kind of a housekeeping note, I need to mention that this is today's event is sponsored by Lawyers Mutual Insurance Company. And Lawyers Mutual Insurance Company, for those of you who are not familiar with it, has for 5 decades been the only California-based company to continuously provide lawyers with professional liability insurance coverage. Their experience and expertise are complemented, by the fact that they are directed by a group of dedicated lawyers. They offer special rates with competitive programs for a wide range of areas of practice, including entertainment law. And you can learn more if you go to lawyersmutual.com. I will mention that apparently I've just learned they have an ethics hotline similar to the State Bar ethics hotline. So if you do sign up with them, you can give them a call and say, hey, we have an ethical quandary here or ethical question, and they will respond to that for you. So that's kind of a handy tool to have. And now I am excited to announce Ashley Defantorum, our speaker today. Ashley is an attorney at Kinsella, Hawley, Isser, Kump, and Steinspar. If I'm butchering that. That's a mouthful as it is. But they are a preeminent litigation boutique for entertainment, media, music, and IP matters. Ashley handles a wide range of entertainment litigation, including breach of contract, copyright and trademark infringement, and employee claims. She also leads workplace investigations for companies in response to employee complaints of discrimination, harassment, and retaliation. I will elaborate on that just for a quick second, because that is somebody that's handy to know if ever a client comes to you and says, we're having an employee dispute. You as the attorney don't want to do the investigation. It's really good to utilize outside counsel such as Ashley to do an objective investigation into the matter. I've done that for clients in the past, so that is a very handy service and skill that she provides. She has also served as outside pro bono counsel to GLAAD, which is a national organization with a mission to garner full acceptance of the LGBTQ plus community through accurate media representation. Beyond work, Ashley is active in the community and dedicated to public service and promoting diversity. She's volunteered for the LGBTQ plus centers and has created an elimination of bias CLE presentation titled exactly that, LGBTQ plus allyship for legal professionals, which she has presented to several companies and organizations. And with that, I'm going to turn it over to Ashley. And thank you very much, Ashley, for agreeing to do this. And thank you for your time. Everybody, please enjoy the presentation.
Thank you so much, Keith. I really appreciate it. As Keith mentioned, I'm Ashley Defantorum, and I work at Kinsella, Hawley, Iser, Kump, and Steinspar. We're a boutique entertainment litigation firm that goes by KICS for short. And although we can go ahead and go to the next slide, sorry. Thank you so much. Although I'm a litigator, I really do have great respect for the work that transactional attorneys do. Really, the way I understand it is that transactional attorneys are really what run the entertainment industry. You're the architects, right? You're the ones building the deal structures, anticipating the business needs, aligning the incentives, and trying to prevent the disputes before they ever arise. So when things go well, the project just moves forward and litigators like me just never get involved. But sometimes, as you all know, the parties are going to fight with each other. And sometimes that's going to happen, regardless of how solid your architecture is. Honestly, it's extremely rare, if ever. I really can't recall a specific situation off the top of my head of handling a litigation matter and thinking to myself that the transactional attorneys really messed it up. In fact, more often than not, the problem is that maybe that no transactional attorneys were consulted in the first place. So maybe the parties were operating off of handshake deals or informal understandings, or even the assumption that the paperwork would come later down the road. And then sometimes, obviously, transactional attorneys are involved, but maybe the deal memo never became a long form agreement, or maybe everyone just assumed again that this would be something that would be papered later and then later never came. And then even in cases where there is a formal and negotiated agreement, the issues being litigated are often very like incredibly nuanced issues. And from my experience, they tend to arise from how the project actually unfolded in practice and not from any like glaringly obvious drafting failure. In many of those cases, there's actually seemingly very little the transactional attorney realistically could have done to anticipate how the facts would later be framed in litigation, which maybe sounds a little bit daunting, right? Because we all want the magic formula of how to draft something so that there will never be a dispute. But from my experience, sometimes there's gonna be disputes regardless of how it was drafted. So my goal, with this in mind, I really have kind of two things I'm going to go through today and two ultimate goals. The first is that I want to walk you through some of the specific and nuanced issues that I've seen come up on the litigation side or even the pre-litigation dispute side, including those like nuanced and hard to spot issues. My goal with this portion is just to give you some additional perspective or ideas on where the exposure might tend to arise, right? So the idea being, even if there's not a magic formula to create an agreement where it will never ever be disputed, to still see some of these nuanced examples of where things fell apart. And maybe that helps inform for your clients or for a situation where similar things might come up. And then really the second part of the presentation, I'm going to spend some time talking specifically about what happens in a situation where a company has a creative professional contribute to a project, but the parties fail to sign an agreement before that project is complete or before it's released into the public. And this portion is kind of going to be at a little bit of a higher level in some ways, because obviously that topic in and of itself could be talked about for hours. But this is an issue I've heard transactional entertainment attorneys come across. That is specifically the issue where the production company hires the creative professional to work on a project, but they never happen to end up executing or signing that agreement. So I wanted to be sure to go over that. And then I should have time to answer hopefully at least a few questions at the end of the presentation. So please do feel free to drop any questions you have in the Q&A portion, and I'll do my best to get through them at the end of the presentation. And then if we run out of time, I'm always happy to chat individually offline as well. Next slide, please. Thank you. Okay, so first, as promised, I'm going to spend some time talking about the entertainment litigation issues I've specifically worked on. Again, these issues are going to be incredibly nuanced, but I think it's helpful to share them because perhaps they're going to shed light on where that exposure tends to arise, which can then obviously help you all or help transactional entertainment attorneys when they're putting the contracts together. Next slide, please. Okay, so this first matter is a pre-litigation dispute that was resolved discreetly without litigation. So obviously, for all of these, I'm not going to tell you any of the parties' names or the precise details of any of the films or the projects at issue, but I can obviously speak about them more generally. So this matter involved a documentary film about our client's primary business. Our client ultimately bought the production company and the producer out of the project. So our client, through a written agreement, acquired all of the rights, the title, and the interest pursuant to that written agreement that was signed by all of the parties. Important for this matter is that the written agreement limited the production company's ability to promote or publicize the film. It included, I think this is standard in these types of agreements, right? So some sort of section where, this one required prior written permission to make pretty much any statements about the film whatsoever. And importantly, kind of feeding into that or related to that for this issue is the agreement also stated that the production company would have to return some portion of the purchase price for the rights if they breached this portion of the agreement. But then after the agreement was executed, the production company in this matter continued to make some public statements about the project and they did so without first getting that prior written permission. So, for example, and probably most troublingly to our client was the production company would go to some of the film festivals and speak with the organizers and sort of preface what the film was about. And there were different things going on there that our client didn't want happening, even just for the optics of there should really be one point person, our client thought, in speaking about the project, and the owner wanted it to be themselves and not the prior owner. So in doing that, we put together, the demand letter, asking them to stop, pointing to the points of the agreement as one would do in this type of dispute. So we carefully explained that there was a breach of the agreement, and then, the ramifications, and just really just wanting them to stop the actions, cease and desist letter. The production company responded by claiming that they were within their rights to talk about the project to the organizers of the film festivals. And to support their argument, they cited one single sentence that it was one sentence in the agreement that did allow that production company and the producers, so the prior owners, to make reference to the project and the producer's professional publicity. That point is really why I wanted to talk about this matter, because I know those types of sentences or clauses and these types of like acquisition rights deals are common, right? So practically speaking, the prior owner of their, in this case, the producer, is still going to want to be able to credit themselves, have it listed on IMDb and those types of things, right? So to be able to reference their work on it in a professional publicity makes sense. But in this case, I think it was interesting because it was being used to, in our client's view, to open the door to more things that the parties didn't intend. So we responded that unsurprisingly, we disagreed with their interpretation of the sentence, and pointed back to the whole section that was dedicated to needing this prior written permission for the company to talk about the film. And we reiterated the fact that we didn't want them to continue speaking with the organizers of the film festivals. Now, the end here is, they never wrote back. To my knowledge, the client got what they needed. Those types of communications stopped, which is obviously good for our client, for the parties involved, for the film itself. But the takeaway here really is, I think it emphasizes the importance of detailing exactly what the parties want in the written agreements, right? So here the parties, again, from our perspective, clearly intended that the production company wouldn't make any public statements about that project unless they get the prior written authorization. But there was apparently some confusion over a separate sentence that did allow that production company to make reference to the project in their professional publicity. So perhaps, I guess, for one takeaway, perhaps an even stronger way to write that portion would be, you could add a sentence immediately following that sentence about professional publicity, stating that, nothing in this clause is intended to alter that other section. It's very, I know that's common. A lot of you probably already do it, but just, it may seem like a minor detail, but thought it might be helpful to point that out. And I also wanted to point out that it was hard for the drafters of this agreement to assume exactly how the production company might interfere with the project in the future. Like, I don't think I don't think our client genuinely thought there was a possibility here or any confusion where the prior owner would go speak to the organizers of the film festivals. But, thankfully here, I think the agreement was drafted in a way that was specific enough, again, at least we think, to cover these specific circumstances. Next slide, please. Thank you. So I also want to briefly discuss another pre-litigation dispute that was resolved, again, discreetly without litigation. So for this matter, we represented an individual who was hired by a company in the entertainment world to introduce television projects on which the company would provide their services, right? And I'm being vague here intentionally because I don't want to give too much away. But I think this is, in other words, so our client was hired on a commission basis to bring new business into the company. And the parties later parted ways, and our client claimed that the company still owed him. Frankly, all parties agreed that there were still monies owed under the agreement. The issue just became how much and based on what, and I'll get into that. But I think it's interesting to pause for a second and flag this because I know this structure of having bringing in a contractor or a worker to be paid on a commission basis is popular in many industries, frankly, but obviously I think it's popular in the entertainment industry in particular, where so much of the business and the deals are sort of relationship based. I've seen quite a few commission based agreements like this. So the parties for this matter had a signed written agreement, but the agreement itself was incredibly vague. And in this, I don't believe it was actually written by a lawyer. It was like a one-page agreement that was, I think, like 10 lines. Like it was incredibly vague. And essentially it said that our client, the worker, would get a bonus for introducing projects and that the bonus would be capped at a certain amount per year. Now, as I mentioned earlier, our client ultimately parted ways with the company, but there were still monies owed under the agreement. But there was disagreements on how much was owed and what calculation was to be done. So we got involved on behalf of the client, where ultimately we were able to resolve that matter through just discussion and negotiations with the company's attorney without having to ever get to litigation. But highlight this issue or this pre-dispute matter because pre-litigation dispute matter because the issues we went back and forth on with the company's counsel had really just everything to do with how vague that one-page agreement was. So, for example, the agreement was missing several key details, such as the written agreement was missing these details. So the first was what counts as an introduction by our client. So what happens if our client introduces the head of a television series to the company, but there's someone else in the company who's already kind of met someone else at the entity being introduced, right? So would that count as an introduction? I think and in speaking with some other transactional entertainment attorneys, I know that can be somewhat of a common issue, right? And I know it's hard to paper as well, but at least to have your clients, to have them, to flag this for them, that sort of vagueness or what does introduction mean to you? What do you want it to mean? And kind of thinking about these scenarios beforehand and finding a way to draft those into the, written agreement so that all of the parties are on the same page, I think would be helpful. Another issue in this particular matter was when do the commission payments become due to our client? This was a big one because this specific agreement, understandably, the company wanted to cap the commissions for cap it at a certain amount each year, which our client agreed to. But then the disagreement and the issue became, well, when are the payments due, right? So does the company owe the payments to our client, owe the commissions to our client at the time the company receives the money from a project, or only once that entire project is completed, right? Because you might be working on a project and you're paid in pieces, and then eventually if it's television, the entire television season is over. So is it based on when the company receives the payment, sporadic payments, or is it based on overall wrapping and end of the project? Again, that was an important detail here because the parties had agreed to cap the commissions on an annual basis. The kind of last big issue here was what happens if our client introduces a television project to the company and the company ultimately does services for several seasons of that television show, right? So it was pretty clear on the face of the written agreement that, for introductions made for a season, of course, he's going to get payments. I think everyone agreed with that. But what happens on follow-up seasons? What happens if you introduce a project and it's very successful and it continues for 5, 6, so-and-so seasons? Is he also getting commissions for that or is he not? Of course, we had our arguments back and forth in this, but I think the lesson here is really to encourage your clients to think of these issues, discuss these issues with the other side, negotiate them, and get them into the agreement, the formalized document, just to try to help prevent this type of situation. Next slide, please. Thank you. This next matter is a consumer class action case that was filed in federal court against a retailer and its influencers, alleging that the influencers did not properly disclose on social media posts that they were being compensated by the retailer to make the posts. Plaintiffs in this case argued that the retailer and its influencers had schemed and devised a plan together to have the influencers discreetly post about the retailer's products to essentially trick customers into buying the products. So ultimately, this case was about essentially false advertising allegations and some other related claims. And the same plaintiff's counsel for this case actually filed a number of these lawsuits around this time, I believe, last year in courts across different jurisdictions. So I saw a few in the Central District here in California. I saw some in this particular one was Illinois federal court or Illinois District Court. So in different places, I just wanted to flag that this is happening. And pausing here for a moment, I know I'm getting, again, this is my point of trying to get, I know these are very nuanced issues, but again, some of the examples of things I've worked on in the past year or two that I think could be helpful. So that's why we're kind of jumping around a little bit on some of these different nuanced issues. In this matter, the plaintiffs, frankly, for all of these class actions they filed last year, they pointed to the FTC's 2023 guidelines for social media influencers, which I've clipped the relevant portion I wanted to talk about here. So it says, if you endorse a product through social media, your endorsement message should make it obvious when you have a relationship or material connection with the brand. A material connection to the brand includes a personal, family, or employment relationship, or a financial relationship, such as the brand paying you or giving you free or discounted product or services. So, in other words, it's stating that the influencers should disclose when they're getting paid or getting free product to post on Instagram and on other social media sites. Now, in this case, plaintiffs argued that the influencers needed to put clearer disclosures on their posts that clarified that they were being paid by the retailer to make the posts. But notably, neither these FTC guidelines, or frankly, any FTC guidelines, or any law at this point, any kind of all-encompassing federal law, states what constitutes a sufficient disclosure on the social media posts. So for this matter, it was kind of a unique scenario. The retailer is a client of the firm, but for this matter, we represented each of the individual influencers, and the retailer had its own counsel. Ultimately, the parties did enter into a global settlement, and the case was dismissed very early on before there was even any formal response to the complaint that was filed. Obviously, I'm not going to provide any details about the settlement, but I can tell you if it hadn't settled, we had prepared and planned. I do think there are arguments that could be raised against some of these claims, and there are of the other cases that were filed that were similar to these with same plaintiffs' counsel. I believe some of them have been dismissed, or some of the claims have been dismissed pretty early on. So it's kind of interesting to watch it play out. But regardless, I wanted to flag this. I think a takeaway from it is that, as I mentioned, this is one of several class actions that were brought by plaintiffs' counsel last year on this exact issue. And unfortunately, that FTC guidance does not expressly state what the influencer must put on their post to disclose that relationship to the company. But I think this means that it's kind of been a little bit of a hotbed for litigation right now, or at least, recently within this past year. And it might be worth it to flag that issue to those of your clients who are either influencers themselves, or maybe they're companies that work with or hire influencers for advertising or other things. So, for example, the company might want to include in their contract with the influencer precisely which hashtags or which disclosures the company wants the influencer to include in their posts. Now, obviously, this leads to that natural question of what should the disclosure be and what's sufficient under the law. But as I mentioned, that the answer to that question isn't entirely clear right now because nothing expressly states that. But I can tell you one option, again, it's tough because there's nothing that's been black and white. This is good, this is not. But just a suggestion or one option that could be included is hashtag, company name partner on all of the promotional posts. And also potentially, if you want to be cautious as well, to include something like company partner even on the bio and like the Instagram page or on TikTok or wherever the influencer is posting things for the company. Next slide, please. Okay. So for this one, it's kind of going to dovetail nicely into the second portion of this. But this is, I wanted to talk about a copyright case that we filed in, obviously, federal court a few weeks ago. So for this case, my firm and I, we represent the plaintiff against a production company. Again, I won't, give specific names or even the case name, but just I think it is a helpful one to talk about. So plaintiff in this case is a songwriter, a singer and songwriter. But for this one, he had been approached by the production company to write and produce music for an animated film. The key part of the pitch to get him to write on it was that the song was going to be sung by a particular kind of like a megastar singer or artist. The production company had promised that that recording of the song by the megastar would then be included on the soundtrack for the film, that it would be released in a single, and that the production company would make the song a full marketing campaign, including for an Academy Award. The production company continued, to kind of reiterate that was the plan all along for I think it was like 2.5 years. So the songwriter had, was working on the song. At some point, he was asked to write another song for the same film and did so. Now, the parties in this case had begun negotiating licenses for the songs and for the recordings. So these would be the work made for hire agreements. And those negotiations kind of throughout the process were based on an economic framework where there was this understanding where the megastars, piece that her song would be pushed for, like given a full marketing campaign and released as a single. Just the deal structure was based on that essentially. So less money up front for our client, but potentially stronger back end with the commercial release of the song. But then just a few weeks before the release of the film, the company told the songwriter for the first time that that one particular song by the megastar was no longer going to be commercially released at all. As you can imagine, that shifted the tides quite a bit, and the negotiations halted as a result. Our client had made its demands for, in his perspective, now wanted more upfront money since there wouldn't be back end because it wouldn't be commercially released and all these things. Essentially, though, the deal fell through. There was certainly no signing of any written agreement, and the animated film was released with both of the two songs in it anyways. And the production company never paid for any of the song for either of the two. So there's 4 copyrights, right? Because there's in 2 of the songs. So there was no work made for hire agreement on either of the songs. And there also was no payment for either of the songs. And the kind of talks and negotiations or demands for payment and for these things in a different agreement continued after the film's released, but it halted at some point. Essentially, that's the punchline: is there was never signed agreements and there was never any payment for use of any of the 4 copyrights. So as a result of that, our client or the songwriter has sued for copyright infringement, there's some misrepresentation claims, and there's both intentional and negligent misrepresentation claims. So in this case, we haven't yet stated the amount of damages that we're seeking, but I can tell you the types of damages for this type of case would be compensatory damages, disgorgement of profits, punitive damages, attorney's fees and costs, and potentially even injunctive relief as well. Those are the types of damages in these copyright claims. The takeaway for this one is really that it's, I wanted to flag this because it's going to be it's a costly dispute, right? It's arguably not fun for anyone except maybe the litigators to actually be in litigation, right? And for this matter in particular, I know the production company has put forth its position that, their kind of hands were tied at the last minute. it wasn't their fault that the song couldn't be commercially released. It had to do with other issues. But even then, you know, from certainly from our perspective, but I think also just the legal perspective, the production company is probably going to be on the hook, right, for promising one thing, it not happening, and for deciding to then continue to release the film with the two songs in it without paying for it and without any sort of written agreement on it. Um, and the, you know, I think just coming from the production company had the choice, to release the film with those copyrighted works in it, without first getting the permission or the license to do so. And that was really, I mean, that's the takeaway I kind of wanted to flag for this one. But I think if we can go to the next slide, I think this dovetails nicely into sort of the second half or the second portion of the presentation, where I wanted to talk about what happens when a creative contributes to a project without signing an agreement. So as you know, it's important to get written, signed, work made for hire agreements in circumstances like this, where the creative, or excuse me, where the company has a creative contribute to a project. Next slide, please. So first I want to go over a little bit of background regarding why this is important. So under US copyright law, the person who creates the work is by default considered the owner of the copyright. That's true unless there is a written and signed work made for hire agreement between the company and the creative professional. So if there is a signed work made for hire agreement, then the company for which the work is created and not the creative is the owner of that copyright. But if there is no signed agreement, the default rule is that the creator is the copyright owner. So for example, maybe just like the example I gave, maybe a studio or a production company hires a songwriter to write a song for an animated film. But you see it in other areas too. So maybe you hire a dance choreographer to create a sequence for a television show, or a writer to draft a scene for a film or a television series. So without that signed work made for hire agreement, any copyright created for the project is owned by the creative and not the studio. That's going to be true even where the studio pays the creative, and also even when it's clear, even if it's otherwise clear that all the parties agreed that the work was created for that commercial project. So then what happens when the project is released without the company first getting that signed work made for hire agreement? Well, the creative professional can assert different types of claims against the company. Some examples of the most common types of claims are breach of implied contract, copyright infringement, fraud, and just kind of another bucket of employment related claims. So the creative could even bring all of these claims in the same lawsuit against the company. As you can imagine, this could get pretty messy and big, blow up into a big dispute much faster than anyone probably wants it to. So next slide, please. This leads me to my next point. So, okay, so what's at risk? What do these claims actually mean, and what's at risk for the company? I want to talk about the damages that the company might owe if they lose on any of these types of claims. And you may already know this, but I found it, even for my own practice, to kind of go through and write it out. I thought it might be helpful. So for breach of implied contract, other types of damages involved for, but essentially the most important one to know for this is if the company loses on this type of claim, it's going to owe the creative the value of the creative's services. Other damages like punitive damages and injunctive relief are typically not available on a breach of implied contract claim. But for copyright infringement claims, this next one, the stakes are much higher. So if the company loses on a copyright infringement claim, it's going to owe the creative several different types of damages, including compensatory damages, disgorgement of profits, the creative's attorney's fees in pursuing the claims. Statutory damages are also available, including enhanced ones if it's determined that the infringement was willful. And then injunctive relief is also available on copyright infringement claims. So obviously something like injunctive relief, which would require that company to stop exploiting or distributing the project, could be dire for the company after, in many instances, they've likely spent years and a lot of money to help develop and create the project. Now for fraud claims, This would be the type of claim where the creative says that, kind of similar to the one I just mentioned, or we just walked through the specific example, but it's where the creative says essentially, the company promised me that they would give me X, they knew they wouldn't give me X, and then it induced me to provide the services, and then they didn't give me what was promised. For those types of claims, if you're able to prove them on the creative side, the company would be liable for punitive damages as well. Punitive damages are the damages that are meant to punish the other side. So the jury is allowed to take whatever the actual damages are and multiply them by some amount. It could be different courts have different rules, but typically it's up to like 10 times the amount. So for example, but I think it's a little bit rare for it to go up to 10 times unless it's, whatever the issue is the jury finds it's essentially so outrageous or warrants a lot of punishment. But even let's just take a 3-time multiple. So let's say actual damages, a jury finds actual damages of 5 million. And let's say they do a 3 times multiple for punitive damages because it was fraud. That would be 15, right? So that would total the 5 plus the 15 and 20 million. So that inflates the claim from something, or inflates the damages amount quite a bit for, if the plaintiff's able to prove fraud. Now, related claims, essentially these types of claims would look like where the creative would argue that they were misclassified as an independent contractor when they should have been treated as an employee. For those types of claims, if the worker is successful, this would open the door to a myriad of different issues for the company. The company could face liability for unpaid wages or overtime, employee benefits, payroll taxes, penalties, interest, attorney's fees, and statutory penalties. And all of this would add up very quickly, as you can imagine. So that's a little bit of what's at stake for the company if the project is released without the company first getting a signed work make for hire agreement. Next slide, please. Thank you. Okay, so now I want to talk about how courts deal with claims in the entertainment industry for breach of an implied contract and for the copyright infringement claims. For purposes of this presentation, I'm not going to dive into the fraud or employment claims just because we just don't have enough time. And I think it might be a little bit more helpful to go through this breach of implied contract and the copyright claims in this instance anyways. So first, let's walk through the breach of implied contract claims. In California, contracts can be formed by words or by conduct. A contract formed by words can, of course, be written or it can be verbal. And I want to pause here just for a second to emphasize that this means there can be times where the creative professional can say that there was a verbal agreement reached with the company. Of course, the issue is then going to be proving or disproving, depending on what side you're on, what was actually verbally agreed upon. But as I said, California law states that contracts can also be formed by conduct in addition to words. So when contracts are formed by conduct, these are called implied contracts. The implied contracts must have all of the same elements of the written or verbal contract. So there's going to need to be mutual assent, consideration, and everything else that's normally needed for your standard written or verbal contract. You need the same for implied contracts. The only difference is that the agreement is formed by conduct of the parties. So, do California courts recognize the existence of implied contracts? Absolutely. But what does that look like in this context where the company hired the creative professional to contribute to a project, but the parties later failed to sign an agreement? Well, to answer that, I want to examine some of these cases here. So the seminal case on the issue of implied contracts in the entertainment industry is a California Supreme Court case from 1956 called Desney versus Wilder. In the Desney case, the court ruled that a creative professional can state a claim for breach of implied contract, even where the work created does not itself constitute a copyright. I'm going to say that one more time because it's super important. So in this Desney case, the California Supreme Court held that even if an idea itself is not protected by copyright, is not unique enough, or for whatever reason does not constitute a copyright, the creative could still have a claim for breach of an implied contract. The I point out this case is it really is honestly the seminal case for this, and it remains the law today. It's nearly always referred to in idea submission cases, and those are cases where a creative or a person argues that they had the idea for a project and the company should be paying them for that idea. Now, the Desney case was about a writer who submitted to Paramount an idea for a photo play. I actually had to look what that word up. I had to look that word up because I wasn't sure what it meant, but apparently it's an old-fashioned term for film. This is a case from 1956. But when the person presented the idea, he told Paramount that he would like them to pay him if they used the idea. And then later, without paying the writer, Paramount released a film that the writer claimed was based on his idea. So ultimately, the writer sued Paramount. And Paramount argued that the entire lawsuit should be tossed out before ever getting to a jury because the writer's idea was not unique enough to constitute a copyright. The court agreed with Paramount that the idea couldn't possibly be a copyright because it wasn't unique enough, but it still held that the writer might be able to prevail on a claim for breach of an implied contract. Now, this next case is the Grosso versus Miramax Film Corp case from the Ninth Circuit back in 2004, but it's still good law today. So this case kind of expanded on or explained the Desney case a little bit more. So for this one, it put forth the standard of how to state a claim for breach of implied contract under Desney. It said that the plaintiff would need to show that three things: that the plaintiff prepared the work, that the plaintiff disclosed the work for sale, and did so under the circumstances under which it could be concluded that the offeree voluntarily accepted the disclosure, knowing the conditions on which it was tendered and reasonable value for the work. In that case, in this Grosso or Miramax case, the writer had sued Miramax for both breach of an implied contract and for copyright infringement because he claimed that he submitted a screenplay to Miramax and that Miramax subsequently released a film that was based on the writer's idea. The film at issue, by the way, was the Rounders film. But the court in the Miramax case agreed to toss out the copyright infringement claim early, finding that the two works were not similar enough to constitute copyright infringement, but it nonetheless held that the writer might still be able to prevail on a claim for breach of implied contract. Now, the significance of these holdings are that even if the work at issue isn't copyright, or even if the two works are so dissimilar that there could be no finding of copyright infringement, courts would still let those claims for breach of implied contract go through and reach a jury. For context, I think it's important to note here, it costs significantly more to litigate a case through a jury trial than if the litigation is resolved earlier, right? So this might be somewhat intuitive, but maybe to transactional attorneys, maybe it's not something that's thought about as often, or maybe it is, I'm not sure. But just for what it's worth, I wanted to note that, these types of cases that, this claim can get through to the jury. What does that mean? Well, just to put it in context, it is not, it is common for, if I had to, the cases could cost $1 million between the time of after summary judgment through trial. Like just getting it through trial could cost so much in attorney's fees and in expert fees that I think it's worth noting these types of cases. And really both of these just still emphasize the importance of having the written agreements in the first place, which I know you all know as transactional attorneys. Now, lastly, so I'd be remiss if I didn't mention that back in 2024, my firm successfully defended Mattel against a claim for breach of implied contract. That case did go all the way to a jury trial, and it lasted months, but we got a full defense verdict on behalf of Mattel. So in that case, the plaintiff had met with Mattel and one of the producers of Shark Tank to discuss his idea for a TV show called Playmakers, which would involve adult toy inventors pitching their toy inventions, similar to Shark Tank, where the panel of sharks were made up of children, and then plaintiff proposed that he would finance the show and produce it, and that Mattel would manufacture and distribute the winning toy and be a sponsor of that program. Plaintiff claimed that he disclosed the idea for the show with the expectation that he would be paid if that idea was used, and that Mattel breached that implied contract by deciding not to create or work with him on that Playmaker show, but then 3 years later, financing and acting as the sponsor of the Toy Box. So the Toy Box was a short-lived ABC primetime reality show that was broadcasted back in 2017. And for the case, and I personally wasn't involved, but different partners at my firm were. I think Larry Iser led the way on this one. But we had argued on behalf of Mattel that no implied contract was ever formed, but that even if it was, Mattel didn't breach the purported contract because it didn't use the plaintiff's ideas in the Toy Box show. After a multi-month trial, the jury found that the plaintiff and Mattel had entered into an implied contract, but it found that Mattel did not breach the implied contract. So that's how we get the result of a full defense verdict for Mattel with no money owed to the plaintiff. I flagged this too. I wanted to note one point about this I thought was interesting. So I mentioned earlier that if the creative professional prevails or wins on a breach of implied contract claim, the company would owe the value of the creative professional's services. So in that Mattel case, we had actually argued at trial that even if the jury got to that issue of damages, the plaintiff should still get nothing because there wasn't any value to plaintiff's idea, as shown by the fact that the Toy Box show that was made didn't do well and that Mattel actually lost money on that show. Next slide, please. Perfect. So now that we've walked through claims for breach of implied contract, I wanted to shift gears a little bit and talk about how courts deal with copyright infringement claims under these circumstances. So again, as I explained earlier, more is at risk for the company on a copyright infringement claim than a breach of implied contract claim. Just financially speaking, the buckets of damages are, there's more that's available to a plaintiff on a copyright infringement claim. And that's because on these copyright infringement claims, the company could owe, again, compensatory damages, disgorgement of profits, attorney's fees, statutory damages, and even that injunctive relief as well. So I wanted to talk about a couple of key California cases regarding copyright infringement claims within the entertainment industry in particular. The first one is Effects Associates versus Cohen. This is a Ninth Circuit case from 1990. It's still good law. This is an important case because it held that it acknowledged and agreed that all exclusive copyright licenses must be in writing and signed, just as I talked about earlier. But it found that you could still implicitly grant a non-exclusive license to a company. So in this case, it involved Larry Cohen, who wrote, directed, and executive produced a film called The Stuff. The plot of the film is a little bit relevant for this, and honestly, I think it's a little bit fun, so I'm going to go through it quickly. The plot for the film was that the Earth was invaded by an alien life form that looks and tastes like frozen yogurt, but has secret negative side effects. So a spy hired by a large ice cream maker, obviously a frozen yogurt competitor, uncovers the truth and saves Earth by blowing up the yogurt factory. So for the film, Cohen had asked a small special effects company to create that footage, or certain footage for the film, but specifically also the piece at the end where the yogurt factory explodes. The parties in this case, and they were on the same page, they agreed that they had verbally agreed that Cohen would pay the special effects company for their work, but they never discussed who would actually own the copyright in the footage. And there was no written signed agreement at all. The special effects company ultimately created the footage, gave it to Cohen, but Cohen wasn't super happy with it, so he used the footage, but he only paid half of the price of what the parties had agreed upon. Cohen then released that film with the footage in it, and the special effects company sued Cohen for copyright infringement. Cohen argued that the special effects company transferred copyright ownership to him verbally or implicitly by handing over that footage to be used in the film, such that he shouldn't be liable for copyright infringement. Cohen's attorneys in this case acknowledged that U.S. copyright law requires all transfers of copyright ownership to be in writing and signed. By the way, that comes from 17 U.S. Code 204. But Cohen still, or his side, he still argued that the statute shouldn't apply to movie makers because essentially, I'm not quoting this part, but essentially it was that, movie makers are too busy to making movies to worry about contracts being made. This line of argument in the case made me chuckle a little bit because I think we've all seen it, right? And understandably, right? Like this industry in particular, there is a lot of different pressures and different things where you need to get the project made. And I get that. But the court here rejected that argument and stated that exclusive copyright licenses absolutely need to be in writing in order to count. The court's line with respect to this point that I liked is, quote, "It doesn't have to be the Magna Carta, a one-line pro forma statement will do," end quote. That's from 908 F2D at 557. The court also said this, I'm going to quote this as well. So, quote, "Common sense tells us that agreements should routinely be put into writing. This simple practice prevents misunderstandings by spelling out the terms of a deal in black and white, forces parties to clarify their thinking and consider problems that could potentially arise, and encourages them to take their promises seriously because it's harder to backtrack on a written contract than an oral one," end quote. That's at the same site, so at page 557. I like this because it's kind of what I'm sure it's a lot of the time you spend sometimes even talking to clients and, getting them to understand the importance of the agreement, not just for everything negative that can happen, but or all the litigation that can happen on the other side, but just because it's good for the parties to get their understandings in writing. So I liked that quote from it. But ultimately, so although the court disagreed with Cohen on his argument that there should be no written requirement for movie makers, the court nonetheless tossed out the copyright infringement claim altogether. In doing so, the court explained that although all exclusive copyright licenses need to be in writing and signed, the creative could still implicitly grant a non-exclusive license by creating a work at the request of another and then delivering that work to the user with the intent for it to be used and distributed in the ultimate project. So the court applied that reasoning to the facts of the case and found that the special effects company did implicitly grant that non-exclusive license for Cohen to use the yogurt factory blowing up footage because the special effects company did create that footage at the request of Cohen and then delivered the footage to Cohen to be included in the film. But the court didn't stop there. It also went ahead and noted that because only the non-exclusive license was granted in this instance, the court made a point to state that the special effects company could still do whatever it wanted with that footage. That there couldn't have been an exclusive license because it wasn't in writing. So it was saying that the special effects company could still license, sell, or even give away for free its remaining rights in the footage. The court even went on to kind of talk about, I don't know who else would want or need this footage of a yogurt factory blowing up, but maybe it could go in some type of music video or other projects. The court explained that regardless of whatever the special effects company chooses to do with the footage, Cohen, quote, "will have no basis for complaining, and that's an important lesson that licensees of more versatile film properties may want to take to heart," end quote. So one major takeaway from this case, the takeaway really, I think, from this case is that without a signed agreement, the company does not own the exclusive rights in the work, such that the creative could use the work in any way that they want to. Now, I also want to talk about this 2010 case from the Ninth Circuit called, I'm going to butcher the first name, but it's the Xenon Pictures case. So the case involved a parody film featuring a series of sketches called National Lampoon's TV the Movie. The plaintiff in this case was a writer who brought a claim for copyright infringement, also brought a claim for breach of implied contract, but for our purposes, I want to focus on the copyright infringement claim. This claim was brought against the film's distributor, against the production company, the director, and the screenwriter, alleging that the defendants had used several skits that he authored without his permission and without payment. So the defendants in this case moved for summary judgment, arguing that the undisputed facts demonstrate that the writer at most co-authored those skits with them, and as co-authors, defendants can't be liable for infringing the copyright. because they're co-authors. The district court granted defendant's motion, but the Ninth Circuit, so this Xenon Pictures case, ultimately reversed the lower court's decision. The Ninth Circuit in this case explained that, quote, whether defendants made any independently copyrightable contributions to the skits is hotly disputed, end quote, such that the issue must be decided by a jury and not at summary judgment. Now, like I kind of touched on earlier, this is important because when claims make it past this summary judgment phase, it means they're going to go, get to trial unless it's settled before. And going through to trial will cost significantly more, obviously, to litigate the case to that point than it would be if the defendants here were able to prevail at the earlier stage of summary judgment. Next slide, please. Thank you. Okay, so I did a lot of talking and I wanted to give a chance to have you all ask questions or, yeah, to answer any questions you might have. So I can take a look in the chat to see if there's anything that's been posted, and feel free to ask in that Q&A portion. The first one, usually treble damages makes the total award 3 times. So it'd be 15K, not 20K. You are correct. My math is not always my strong suit. So yes, I think you were talking back to when I mentioned punitive damages and that it could be up to 10 times. And then for my example, I gave, let's say it's 3 times and I'd say actual damages are 5 million, which you're right, would make then the punitive damages 15 million if it's a 3-time multiple. Let me see. Must the work for hire agreement be signed before the work starts, so a later work for hire agreement might not be effective? That is a good question. So the standard for it being, I think typically what I was speaking on is you certainly want to have it signed before the project is released, because that's when, or is distributed in any way, because that's where it would trigger the use of the copyright, right? So you want the permission to be given certainly before it's ever released. I think in practice, obviously, most ideal, you would want it to get it done ideally on the front end. I think that would be a most ideal world. But as far as triggering the piece where you could be at risk for infringement, I believe that would come after the work has been, publicly displayed. So after it's been distributed or introduced into the market, you most definitely need it before that point. But that's a good question. Certainly something to keep in mind that and just I've seen this. I've heard of it happening so many times from friends who are transactional entertainment attorneys, where there are negotiations or there are talks or there's an understanding between the parties, and yeah, we'll get to the papering of it later. We'll get to it at some point. But then think of the position it can put the company in too, right? So you've hired this creative, or you're working with them, and you're on the same page about what it's going to look like, but you don't yet have that signed written agreement. They do all this work and now you're ready to release it, but you need them to sign it before they release it. Sometimes those creatives can be hard to track down. Sometimes it's not like a nefarious, thought process on the creative. Sometimes they're just, again, hard to track down or hard to pin down and get their signature on the page. So certainly in practice, wanting to get it done as soon as possible, I think is the best advice. Did Disney ultimately prevail based on implied contract? That is a good question that I should know, but I, for some reason, don't have it off the top of my head. I don't recall off the top of my head of how that ended up, but I can certainly, I see Ralph asked that question. I can connect with you after. That's a good question. Okay. What about where defendants can assert an employment relationship work for hire, not a commissioned work? No writing required, right? How challenging do you find proving or disproving such a relationship? So in the employment, I have done some litigation in the employment context, and I can tell you that proving and disproving, the worker classification on whether they're employment or independent contractor, I think that's part of your question. I hope I'm answering it. Um, it can be difficult, and it is it's relatively rare for a claim like that to get kicked out early at the dismissal or certainly at the summary judgment stage. So definitely difficult in that sense. And I know California law in particular has changed quite a bit, starting back in 2018 on the different worker classification standards and what the courts are looking at as far as it's become a little bit more fuzzy or a little bit more difficult, I would say, for the employer or for the company to prove that the worker was just an independent contractor. But you are correct. You are correct in that if it's an employee working for a company, there does not need to be a work made for hire agreement. It's assumed that by default, the copyright then belongs to the company. Oh, and Jay said that he thinks that Desney settled. Perfect. Well, that settles that issue. Makes it easier. Thank you, Jay. Are there criterias to prove an implied contract strict regarding the interpretation of the facts? Are the criterias to prove an implied contract strict regarding the interpretations of the facts? That's a good question as well, Mohammed. So for an implied contract, first of all, if you're talking about the interpretation of the facts, you're at the jury stage. So you're past, this isn't something that's going to be, if they need to look at the facts for it, right? It's not going to be on the summary judgment stage unless it's undisputed facts. But I think that gets into, I'm not sure exactly how to answer this one. It's a little bit tougher to answer because it is something, if they're getting into the facts of what happened here, were they presenting it with the intention of getting paid? Like, yes, it can be messy and tricky, and it's going to be up to the parties and the attorneys at trial and what they try to show to persuade the jury one way or the other that the facts point to no implied contract or there was, and then, because there's multiple elements to it. There's proving that there was an implied contract, and then breach, and then damages as well. And I think that's all and I hope that answered your question, by the way, Mohammed. Feel free to reach out to me, and all of you, honestly. If you want to reach out to me, I'm more than happy to talk one-on-one to answer any other questions you might have. Okay, we've got one more from Judith saying, did you mean a moment ago that in an employment agreement, the employer does not have to state that the employee's work is work made for hire? So I apologize if that's how it came off. The employment agreement should certainly make it clear that it's, any work being created in the context of that employment is absolutely a work made for hire. So if I misstated, I apologize. You should most definitely include that in the employment agreement. What I meant is if you have an employee with that employment agreement already in place, then for each individual project, are you going to need the employee to sign a completely separate work made for hire agreement? No, I think that overall employment agreement with the work made for hire clause in it should suffice. Okay, perfect. I think that's all we had. Again, please feel free to reach out to me, and thank you to the Beverly Hills Bar Association for having me.
This concludes today's presentation. Thank you so much, Ashley, for an excellent program, and thank you so much to our audience. Have a great day, everybody.
Thank you.